Leon van Gas. I appear on behalf of the first to 6 respondents as well as the 14th respondent today.
Thank you.
May it please the Court, Chief Justice Cameron, I appear for the 12th respondent in this matter.
Thank you.
May it please the Court, Chief Justice and Justice Cameron, I appear on behalf of the 8th respondent, the ANC.
Thank you.
Good morning, Justices, and may it please the Court. My name is Cook. I appear for the Democratic Alliance.
Thank you. This is a majority judgment that I have written in which Moseneke DCJ, Busielo AJ, Cameron J, Froneman J, and Zondo J concur. It will hopefully complement all measures designed to and embarked upon by the IEC already to guarantee the freeness and fairness of our elections and intimately connected processes. Guidance is given on what the IEC is required to do to compile a rule of law compliant national voters' roll and what additional measures it would be well advised to put in place. All this flows from giving meaning to this Court's calm order, its prospective application, and that of Section 16(3) of the Electoral Act, a proper construction of the words addresses where available in Section 16(3), and a subtle suggestion to Parliament to consider a possible revisitation of the Electoral Act. Between August and December 2013, local government by-elections were held in several wards in the Tlokwe local municipality. Independent candidates were unsuccessful. They subsequently challenged the freeness and fairness of the by-elections on the basis that they asked for but were not given the segment of the voters' roll that applies to Tlokwe and has voters' addresses in compliance with Section 16(3). That challenge was first considered by the Electoral Court before it came before this Court on appeal. And the case has become known as COM. There, we ordered the IEC to comply with the provisions of Section 16(3) by recording all the addresses of voters that are available on the voters' roll for future municipal elections and by-elections. We set aside the previous by-elections and ordered that the next round of by-elections be held before the end of February 2016. Those by-elections were scheduled for 24 February 2016. In less than 2 weeks before that date, the independent candidates asked for the segment of the voters' roll that applies to Tlokwe from the IEC. After studying the voters' roll, they protested on the basis that the voters' addresses were not included. When the dispute proved to be irresolvable, the independent candidates approached the Electoral Court for intervention on the eve of the by-elections. The Electoral Court ruled in their favor, insisting that the calm order be complied with. Aggrieved by that outcome, which the IEC also understood to mean that all the more than 26 million voters must, for the August 2016 elections, have their addresses recorded, the IEC sought leave to appeal from this court. In the event of the appeal being dismissed, it applied for direct access to this court. The latter was prompted by the reality that the IEC would not be able to secure all outstanding 12.2 million addresses before the August elections, should this court conclude that it was obliged to do so. For this reason, this court was asked to exercise its constitutional powers in terms of Section 172(1)(b) to facilitate the holding of the August elections, notwithstanding the IEC's possible non-compliance with the law or the Constitution. The IEC, the Minister of Cooperative Governance and Traditional Affairs, and the IFP sought and are granted condonation for the minor incidents of non-compliance with the rules of this court. Since this matter concerns the elections, which is not only the lifeblood of our constitutional democracy, but is also a matter of general public importance, the interests of justice dictate that leave to appeal be granted, and leave will thus be granted. The merits of the appeal relate to the meaning of available in Section 16.3 of the Electoral Act, the prospective application of Section 16.3, and the application of the CAM order, the applicability of Section 16.3 to local government elections and to independent candidates, and whether the independent candidates changed the course of action in the two stages of litigation. I begin with the meaning of available. Over the years, including 17 December 2003, which is the date on which Section 16.3 came into operation, the IEC's recordal of the voters' addresses on the voters' roll was admittedly erratic. It understood the capturing of that information to be optional. When confronted by independent candidates with a request for a Section 16.3 compliant voters' roll, the IEC understood its obligation to be nothing more than to provide them with a segment of the voters' roll with those addresses that it had chosen to record, not those that are in reality available and therefore recordable. Available, as the word used in Section 16.3, then had to be given meaning by this court. And we conclude that available addresses does not mean those that the IEC chooses to make available or those that happen to have been recorded by the IEC. It means what is reasonably available or objectively available, not merely what the IEC has in its records. Regarding the CAM order, the IEC understands it to require of it to record addresses of voters who registered for the first time or changed voting districts after 30 November 2015, which is the date on which the CAM judgment was delivered. On this reasoning, it does not consider that order to require that it corrects the voters' roll wherever there is a defect in relation to the addresses for the purposes of all future elections. This is an incorrect understanding of the CAM order. That order applies to all future municipal by-elections and elections. And all by-elections or elections held after 30 November 2015 require a voter's roll that complies with the provisions of Section 16.3. This is so because all elections or by-elections held after 30 November 2015 fall within the category of, I quote, all future municipal elections or by-elections, close quotes. The prospective application of HAM seeks to preserve the integrity of past elections and by-elections while avoiding irregularities and defects in the future. The Tlokwe by-elections that were scheduled for 24 February 2016 and the August 2016 elections are all in the future envisaged by the CAM order. There is no reason why that order was not and cannot be complied with, particularly because it was designed to prevent a recurrence of the irregularities previously detected. An order that is in line with this approach would also give meaning to the dismissal of the IEC's appeal against the order of the Electoral Court if that dismissal is ordered. That court made an order that effectively required of the IEC to compile a segment of the voters' roll for Tlokwe that complies with the CAM order. It insisted on the compilation of the relevant segment of the voters' roll so as to address known defects and irregularities. The segment of the voters' roll that applies to Tlokwe should thus comply with Section 16.3, A reference to future municipal elections includes the August 2016 elections nationwide. The IEC's contention that Section 16.3 does not apply to local government elections, but only to national and provincial elections, lacks merit. The reason advanced is that the omission of independent candidates from Section 16.3 and the express inclusion of political parties show that the section applies only to national and provincial elections where there are no independent candidates. This cannot be. Section 1 of the Electoral Act defines election as including an election or a by-election for a municipal election. This then is the same meaning to be ascribed to election in Section 16.3. As for the argument that independent candidates are, unlike political parties, not entitled to have a segment of the voters' roll with available addresses given to them upon payment of the prescribed fee, COM has already provided an answer. It is that independent candidates are entitled to the same rights that Section 16.3 confers on registered political parties. A concern was also raised by the IEC that the independent candidates' cause of action in the Electoral Court is different from the cause of action relied on in this court. It suffices to say that the independent candidate's cause of action before the Electoral Court is substantially similar to what it is before this court, and it was open to the IEC to deal properly with any of the issues raised in both courts. The IEC's failure to correct the clockwise segment of the voters' roll in compliance with the COM order in Section 16.3 was unlawful. It admittedly failed to capture all the available addresses since 17 December 2003 is also unlawful and inconsistent with the Constitution. All of the above then means that the appeal must fail. In the alternative, and in anticipation of the possible dismissal of the appeal, the IEC sought direct access to this court. Knowing that it would be impossible for it to correct the voters' roll between the delivery of this judgment and the August 2016 elections, in order to, in effect, have the August 2016 elections held on the basis of a defective voters' roll, is sought in the alternative. And Section 172(1)(b) of the Constitution provides the solution. The power to make a just and equitable order is ordinarily to be preceded by a declaration that conduct or law is inconsistent with the Constitution and invalid. That power is exercisable by a court when deciding a constitutional matter within its power. Retrospectivity and the suspension of the declaration of invalidity flow from the unconstitutionality of conduct or law, and the power to allow the competent authority time to correct the defect that is at the heart of the declaration of invalidity is dependent on satisfying the above prerequisites. The compilation of the current voters' roll is unlawful by reason of its disregard for the provisions of Section 16.3 and the strictures of the rule of law. This renders it inconsistent with the rule of law, which is one of the cornerstones of our constitutional democracy. It is for this reason that we declare that unlawful conduct constitutionally invalid. The declaration of the IEC's compilation of the National Common Voters' Roll as unlawful, inconsistent with the Constitution and therefore invalid, will be suspended for 18 months from the date of this judgment. This suspension will allow the local government elections scheduled for August 2016 to be proceeded with, notwithstanding the defects in the National Common Voters' Roll. and the IEC will have the opportunity to update the voters' roll by capturing reasonably available addresses during the period of suspension and cure the defects. Come 2019, the National Common Voters Roll would have to be free of defects for the purpose of the national and provincial elections. This obligation relates only to the post-December 2003 voter registration that should have been conducted in keeping with Section 16.3. Desirability and utility will hopefully nudge the IEC to also record the objectively available addresses of all pre-December 2003 voters, while it prioritizes the post-December 2003 voters for compliance. It bears repetition that Section 16.3 is undoubtedly prospective in its application. The IEC's obligation to record voters' addresses that are reasonably available arose only with effect from 17 December 2003. And it cannot therefore be for the courts to impose unbearable or near impossible obligations on organs of state and other institutions. To saddle the IEC with the ongoing obligation to update the voters' roll, as opposed to alerting it to the desirability and utility of doing whatever it can to have all reasonably available addresses sourced and recorded, is a power we do not have and a duty probably too onerous for the IEC to bear. Whether that obligation should rest on the IEC is a matter best left to Parliament to consider and determine. That said, we reiterate that the IEC would do well to optionally have all available addresses recorded from time to time. As for by-elections, they are ordinarily limited to very few districts in the country, and they do not always have to take place at the same time. The IEC should thus be able to ensure that a segment of the voters' roll that applies to a particular district is cleaned up of defects before its by-elections are held any time after the August 2016 elections, but before 30 June 2018, which is a reasonable period of suspension and cut-off date for the correction of the defects in the National Common Voters Roll. For these reasons and those stated in the first judgment, all by-elections to be held following the August 2016 local government elections would have to be based on an updated voters' roll for the affected voters' district. The first judgment written by Madlanga J, in which Kampepe J and Tlandla J concur, sets the background to the case, resolves the applications for condonation, leave to appeal and direct access. It also decides that the appeal be dismissed, all of which enjoy the support of the majority judgment. It, however, differs from the majority judgment in two main respects. First, it goes further than the majority judgment and holds that Section 16.3 obliges the IEC to record all addresses that are objectively available, even the addresses of voters who registered before 17 December 2003. This is because of the functional twin purpose of Section 16.3 to facilitate the canvassing of voters and to enable those contesting elections to verify that voters are registered in the correct voting districts. Bearing this twin purpose in mind, requiring the inclusion of addresses of the voters' roll enhances the fairness of elections, which forms part of the IEC's duty under Section 190(1)(b) of the Constitution. Omitting the addresses of voters registered before 17 December 2003 would defeat the very purpose of furnishing addresses. It would mean that those voters could not be canvassed in a direct and focused manner, nor could the validity of their registrations be verified. Madlanga J holds that on a proper reading of Section 16.3, The obligation to provide a voter's roll with addresses is ongoing. In his view, the IEC cannot be exonerated simply because the pre-17 December 2003 addresses were never captured. It must take reasonable steps to avoid those addresses, to obtain, those addresses, in order to comply with its continuing obligation. This purposive interpretation not only gives meaning to the IEC's obligation in terms of Section 16.3, but also accords with its obligations in terms of Section 191B of the Constitution. Furthermore, this interpretation is consonant with a wholesome exercise of the right in Section 19 of the Constitution, requiring the recording of even pre-17 December 2003 addresses better protects the constitutional rights to vote in and contest free and fair elections. The second point of difference with the majority is that the IEC's failure to record the addresses on the voters' roll, where available, was in breach of Section 190 of the Constitution. This is because the Electoral Act, of which Section 16.3 is a part, is legislation envisaged in Section 191A of the Constitution. The IEC's obligation to provide addresses in terms of Section 16.3 links up with its obligation in terms of Section 191B of the Constitution to ensure that elections are free and fair. The freeness and fairness of elections must be the focus of the management of elections in terms of legislation passed pursuant to Section 191B. 1A, In that context, failure to comply with an obligation imposed by Section 16.3 translates to failure to comply with Section 191B of the Constitution. The interconnectedness is such that Section 16.3 cannot be dissociated from Section 191B. Consequently, the IEC's failure to record addresses on the voters' roll is, according to Madlanga J., inconsistent with Section 191B of the Constitution and falls to be declared invalid. Jafta J, with Nkabinde J concurring, also penned a minority judgment in which he agrees that leave to appeal and direct access be granted and that the appeal be dismissed. But he differs on the order proposed in relation to the application for direct access. He holds that Section 16.3 requires the IEC to furnish addresses that are available to it and that an address would be available if it was obtained at the time of registration. In this context, Jafta J holds that available does not mean exist, but instead means in the IEC's possession. Further, he expresses reservations on the court's power to suspend the operation of an act of parliament, especially in circumstances where the Constitution does not expressly empower it to do so. He holds that this court should not grant an order that allows the IEC to use a flawed voters' roll in the elections, as this would result in unfair elections. Returning to the majority judgment, it bears emphasis that this is an exceptional case that cries out for an exceptional solution or remedy to avoid a constitutional crisis which would have far-reaching implications for our democracy. It is about the upper guardian of our Constitution responding to its core mandate by preserving the integrity of our constitutional democracy. And that explains the unique or extraordinary remedy we have crafted of suspending the duty that flows from a constitutionally valid statutory provision. In the result, the following order is made. 1, the applications for condonation by the Electoral Commission, the Minister of Cooperative Governance and Traditional Affairs, and the Inkatha Freedom Party are granted. Leave to appeal is granted. The appeal is dismissed. The Electoral Commission is granted direct access. The Electoral Commission, that's number 5, is failure to record all available voters' addresses on the National Common Voters Roll is inconsistent with its rule of law obligations imposed by Section 1C of the Constitution and invalid. 6, the declaration of invalidity in paragraph 1 is suspended, and 6.1, the duty of the Electoral Commission to record all the available addresses of voters on the voters' roll for the purposes of the August 2016 local government elections is, except for the Tlokwe local municipality, suspended. 6.2, the Electoral Commission must, by 30 June 2018, have obtained and recorded on the National Common Voters Roll all addresses that were reasonably available as at 17 December 2003. 7, the order in paragraph 6 does not apply to local government by-elections. 8, at 6 monthly intervals calculated from the date of this order, the Electoral Commission must file a report with this court setting out 8.1, the number of outstanding post-December 2003 addresses it has since obtained and recorded on the National Common Voters Roll. 8.2, the number of post-December 2003 addresses still outstanding. 8.3, the steps taken and to be taken to obtain outstanding post-December 2003 addresses. 8.4, any other matter it may consider necessary to report on. 9, the Electoral Commission must pay the costs of appeal and application for direct access of the independent candidates, the Democratic Alliance, and the Inkatha Freedom Party, including the cost of 2 counsel. I hand down this judgment. The court will adjourn.